This time I'll call the next appeal. It's consolidated cases 118834 and 118835. State of Kansas versus Jerry Allen Libby.
May it please the court. James Latta representing Jerry Libby. May I please reserve 3 minutes for rebuttal?
Yes, 3 minutes is reserved.
Thank you, Your Honor. As this court knows, the issue before it is the dispositional departure exception and exactly under what facts those apply. And very few facts are relevant here, and I'll cover those briefly. It's dispositional departure exception took effect July 1st, 2017. Before that exception took effect, Mr. Libby committed his current crime of conviction, and he was presumptive prison. Then after that exception took effect, he pled out and was sentenced. At sentencing, he received a dispositional departure to probation. And then while on probation, he technically violated the terms of his probation. And then due to those violations and due to being on probation as a result of a dispositional departure, the district court instantly revoked his probation without first imposing any intermediate sanctions. And in this case, the Court of Appeals majority relied on subsection C12 to say that the date of violation of probation controls what exceptions you can apply. And my first response to that, as we argued below, would be that the subsection C12, based on the plain language of the statute, specifically the phrase violation sanctions, is only referring to the intermediate sanctions found in C1, and that's partially reading the whole statute as a whole. And I would point this court to every time the legislature used the phrase violation sanctions together, that was only in reference to those intermediate sanctions found in C1. Further, anytime the legislature said the word sanctions in context, they were further referring to subsection C1. And also, I would just point out that the phrase non-prison sanction is a statutory defined phrase that means such things as house arrest. So that phrase should not, in my view, should not be relied on when interpreting violation sanctions. And then, based on that argument, if it doesn't apply retroactively, then we have to determine still what date we go from. And so our position is that we'll go from the date of current crime of conviction, based on Keel, that's our best case for that, saying the penalty parameters and punishment should be set at the time of conviction. And certainly, probation is a punishment. Might not be as bad a punishment as prison, but it's still punishment. And the parameters of probation, they are penalties. If you can revoke someone's probation for a technical violation, if you can't revoke it when they commit their current crime, but you can revoke it after they violate, that's an increase in penalty and increase in punishment. And so based on the ex post facto clause, we'd say you still can't go back.
How do you deal with Judge Atchison's concurrence? Partially agrees with you, but he says there is no violation because the statute went to effect before the probation violation occurred, therefore he's put on notice. What's your response to that?
My response is I partially agree with Judge Atchison as well. If he had pled out before the statute would have been in effect, we would still have a due process notice problem. But he was on notice that it could happen, so that takes care of that. But we still have the penalty issues. So Judge Atchison saw it as he wanted to go from eligibility to probation. But in our view, we don't see how you can separate eligibility from probation and then the penalties within that probation that they place on you. I mean, being able to send someone to prison for something, when they commit their current crime, not being able to send someone to prison when they violate their probation, in our view, is an increase in penalty and an increase in punishment that the legislature is placing on defendants. And for that reason, we still have an increase in punishment based on when the current crime of conviction is committed. And so any increase from there, that's the day we want to go to. And we'd also point out that U.S. Supreme Court precedent has talked about any punishment, which makes more burdensome the punishment after the commission. And that's our reliance. So to sum up, we would just ask that you please find C12 does not apply to the whole statute, just to the intermediate sanctions. And then still going from where we measure prospectivity and the ex post facto analysis, our argument is still we go from current crime of conviction, because that's when the penalty is set, and from there, the probation penalties can't be enhanced after that.
Any questions? Thank you, counsel.
Thank you, Your Honor.
Your Honors, here the state would argue that C-12 clearly shows that the statute is retroactive, and frankly, this is a situation where Mr. Leiby entered his plea after July 1st, 2017, when the Section C-9B was put forth. Not only was he put on notice by statute, but he was also put on notice through the course of plea negotiations, myself talking with defense counsel, that he needed to make sure that his client was aware that this statutory change, that we were willing to grant him a departure, and if he were to violate his probation, what he would be subject to given the statutory amendment change on July of 2017. From the state's perspective, it's very clear from the Section C-12, the language in there, that it does apply to the entirety of that subsection C within the statute, not just merely the graduated sanctions, but the statute as a whole.
The violation alleged here occurred after subsection 9 went into effect, is that right?
That's correct. He entered
So
his-
if that's the date we look at, you don't need a retroactivity argument, do you?
Not from the state's perspective, when he entered his plea on August, I think it was August 17th, the C-9B was already in place. I guess really more where the retroactivity part of it would go is, counsel's argument today was that the law that would be in place as of the time the crime occurred, which would have been prior to that C-9B addition. That still, however, from the state's perspective, that argument is saved from the defense counsel's argument. When you look at how the language in C-12 is written, it allows us to go back to anyone that is sentenced after July of 2013.
I think Justice Stegall was asking about the probation violation, but you're saying that both his plea in the underlying criminal case and his violation occurred after July 1, 2017.
That is correct. The only thing that occurred prior to the change was
the
the crime
actual
of
crime.
conviction.
Yeah.
Correct.
Okay.
So from the state's perspective on this, it's clearly within the confines of what's allowed within the probationary violation statutes, and that the decision of the lower court should be affirmed in this matter.
But excuse me.
Go ahead.
But some of the Supreme Court cases, when they're talking about ex post facto, they look at as far as what was in effect when the person committed the crime, and that's how they determine the ex post facto. And they're saying that if what was in effect when they committed the crime was a benefit to the defendant, like sanctions, that's what you go on. And what you have to say about that argument?
How the state of Kansas has interpreted it.
No. I'm talking about the U.S. Supreme Court. How they have interpreted it. You actually look at the date when the offense was committed. If it was something favorable to the probationary, when the date the offense was committed, they're saying that probationary is entitled to that. And if you make an amendment to change that, that's ex post facto. Because what you've done, when he committed a crime, you had these sanctions that were there, that it could have been a benefit to him. But then if you come along and make an amendment to change that, then that's ex post facto.
At the time he committed the crime, he was presumptive prison, so it was an act of grace that this was made available to him. Frankly, that wasn't there, but if you look at how the state of Kansas has interpreted those Supreme Court decisions and applied them, the state of Kansas is saying this is acceptable, this is the way we do it. We are going to go off of, and I believe it was the Kurtz decision, is what has been, most frequently reported in these cases is the date of the probation violation is what we look at for probation violation hearings. The date of the crime is what's looked at for sentencing purposes, but the date that we look at for the probation violation is the date that violation occurred.
When you say the state's done this, you're relying entirely on Kurtz? Is that right?
That has been the primary argument that has been offered by.
Well, do you have
defense counsel.
another authority? I asked you this in the last case. Do you have anything other than Kurtz to point us to? In terms of how the state has interpreted ex post facto, because I think my colleague pointed out to you in the last case that Kurtz didn't deal with ex post facto. So what are you saying? What are you pointing us to other than the statute itself when you say we have previously ruled on this topic?
It's not where Kurtz and that would be the primary case at this point.
Is there another case? It's not primary unless there's something else.
The other cases beyond that have been since Kurtz, and that those have been unpublished decisions that would be relating to.
It relied
this
on Kurtz.
Correct.
Okay. Do you have anything that doesn't flow from Kurtz? That was my original question.
I apologize. I
That's okay.
misunderstood you.
Now we understand each other better.
Would you agree that?
Off the top of my head, I apologize. I don't.
Okay. Thank you.
Would you agree that Mr. Leiby would have received the intermediate graduated sanction had there not been the new statute? It doesn't have anything to do with the fact that there was a dispositional departure, does it? That's your point, is that it was presumptive prison, but for the enactment of that statute, wouldn't the court have been required to impose the intermediate sanctions upon the revocation?
Without that statutory addition, yes, it would have. He had two cases. The earlier case, he would have been there. But in this particular case, unless the state had made arguments to the effect of him, other exceptions, that would have allowed the court to remand him the way that this matter came forward. But for the departure addition, the court would have been required to impose immediate sanctions unless it would have found one of the other exceptions applied, yes.
Right.
Any other questions? Thank you, counsel.
Thank you.
The court will take this matter under advisement. Oh, I'm sorry. Rebuttal time, y'all. I'm just not used
That's quite all right, 'cause
I'm
I'm
just not
actually-
used to your side being on that side of the table.
Well, that worked out good because I'm actually going to waive rebuttal unless there's any
Okay.
questions.
All right. Well, it wasn't a mistake by me at all.
All right. Thank you.
She was just clairvoyant.
Yeah. Thank you. And now we will take it under advisement.